Good morning, and this is U.S. government, and we're going to try to do an FYI here in 5 minutes or less. Today we're talking about the incorporation principle. The incorporation principle the discussion begins with Barron v. Baltimore back in 1833. The focus at that time, of course, was our federal system and federalism as the concept, federalism being the division of power between the states and the federal government. And in this case, although it was appealed to the Supreme Court said that the Fifth Amendment's protections of due process do not apply to the states, and in this case, the city of Baltimore, that they were intended for protection of our civil liberties against the federal government, but not the states. And that was significant. It upheld that federal division of power and, of course, said that the Bill of Rights applied to the federal government, but not to the states. Now, in the Fifth Amendment, no person shall be deprived of life, liberty, or property without due process of law. And in that case, Barron said he was deprived of his property, or his property was affected, and he was deprived of his profits, and that's why he sued. And originally he won the case, but that was overturned, and then overturning was upheld by the Supreme Court. Now, get to the 14th Amendment, 1868. Okay, the doctrine, the incorporation principle comes up again. And the incorporation principle is essentially the doctrine through which many of the liberties protected in the Bill of Rights are made applicable to the states through the Due Process Clause of the 14th Amendment. The 14th Amendment being one of these Civil War amendments. Now, 14th Amendment, due process for the states. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And the key here, nor shall any state deprive any person of life, liberty, or property without due process. So we have that Fifth Amendment statement now being included in the 14th Amendment and being applied to the states. Okay, so did it happen immediately? No, it did not. Okay, it continued as usual until we get to cases like Gitlow versus New York. And you could argue that really incorporation started in 1925. The Supreme Court partially overturned the Barron precedent by accepting jurisdiction over a case involving free speech, okay, at the time of World War I, okay, because the case itself, the original case went back to 1919, and it was finally resolved in 1925, and they partly overturned it. They said, yes, we will hear it, and they ruled that a New York statute that punished Gitlow for publishing information that advocated the violent overthrow of the government could be restricted, so his free speech rights didn't apply, and they applied this. Of course, the Bill of Rights, the First Amendment, protections of freedom of speech didn't apply here and could be restricted. Okay, that was in 1925, Gideon versus Wainwright. 1963, they overturned a conviction because he was not given a defense. He had no defender. He had no legal counsel. And so they applied that in 1963. They incorporated that particular principle in the Bill of Rights from the Sixth Amendment. And then, of course, McDonald versus Chicago. Now we're in 2010, fairly recently, okay, in which they incorporated the Second Amendment, okay, the right to bear arms, protections in the Second Amendment were incorporated. So over time, and you can see this, there's a list of this in your text, of these cases in your text, that shows over time how these were incorporated. So it wasn't a blanket incorporation of the Bill of Rights. It did happen over time. Gideon versus New York, Gitlow versus New York, Gideon versus Wainwright, McDonald versus Chicago. Now, there are exceptions, things that aren't incorporated, absolutely. Right to a grand jury hearing, right to refuse to quarter soldiers, which some states guarantee in their constitutions, right to a jury trial in civil cases, all right? Freedom from excessive fines or bails. These things were either seen as unnecessary or are guaranteed in state constitutions. So again, not a blanket incorporation of all the civil liberties protected in the Bill of Rights, but over time things were incorporated, and some things still not, and some things not necessary.